Thank you very much, and thank you for the opportunity to speak to you all here today. Like you've just heard, I'm going to be speaking to you about my experiences working for the prosecution team at the International Criminal Tribunal in Cambodia. And what I'll be speaking about is first a little bit about myself and the court and the history of the Khmer Rouge era. And then I'll talk more specifically about my experiences working and living in Phnom Penh. And finally conclude with some observations and impressions that I had of the tribunal. I've been told I'm only allowed to speak for 20 minutes, which is a great disappointment to me because I have so much to say. So I'm very happy to take questions, but perhaps if we do that at the end, and I'm also very happy to keep talking to you about it afterwards. So like you've just heard, I'm a law graduate from Victoria University, and I really became interested in international criminal law a long time ago, but did an honours paper in that subject, and that was really what crystallised my interests. I wanted to do something practical and get practical experience in that area, which is quite difficult for a young lawyer. So all I did really was just Google around the various courts and tribunals and found that they all offer internship programs. So that's what I applied for and subsequently got. Before I talk about the establishment of the court, it makes sense to give a brief outline of the conflict that led to its creation. So, sorry, I should have caught up on that one first. So, very brief history then of the Khmer Rouge. The period of focus is 1975 to 1979, and in that time, a group of radical Cambodian leaders sought to implement what they would see as a communist utopia, which in fact led to the deaths of up to 2 million Cambodians, either murdered by the regime or killed through starvation or disease or overwork. The name you may be most familiar with is that of Pol Pot, but in fact he passed away a number of years ago now, so the people who are of most interest to us are those who are currently on trial. First, Nguyen Chia, also known as Brother Number 2, who was second in command to Pol Pot during that time. Next, Khieu Samphan, who was head of state during the Khmer Rouge era. Ieng Sary, who in fact recently passed away, and I'll be talking about that in more detail soon, who was the Minister of Foreign Affairs. And finally, Ieng Thirith, who is married to Ieng Sary and who is the Minister of Social Affairs. So what did these people do? They implemented a mass movement of the population away from Phnom Penh and other major centres into the countryside in an effort to increase workforces out there to try and increase rice production to become self-sufficient. To that end, they established huge numbers of work sites and cooperatives and had a very, very strong focus on agricultural production. Also, you may be familiar that this group strongly protected Cambodian sovereignty against what they saw as external threats, largely from what they would call the Vietnamese aggressors, the American imperialists, and KGB spies who they believed infiltrated all levels of government and society. Finally, also, there was a strong focus on protecting the party against what they saw as internal enemies. So those were the Vietnamese, like I've already mentioned, and the Americans, but also people like Buddhists, like the minority Cham population, and so on. To that end, they established not only work sites and cooperatives, but in fact large-scale interrogation and execution facilities. And you may be familiar with those through films like The Killing Fields, which was popular a number of years ago. So that's a very brief sketch of what was a very traumatic and turbulent time in Cambodian and indeed international history. And you, in fact, may have your own memories of that period from the time. But you also may not, because there was very limited exposure of the regime during the period. Very few journalists allowed into Cambodia. And in fact, New Zealand had fairly limited involvement in that conflict. But no involvement at all. In fact, one of our own New Zealanders, Rob Hamill, who's an Olympian rower, his brother Kerry was abducted and eventually executed by the Khmer Rouge when he was sailing in waters near Cambodia and was blown off course. And I would really recommend to you watching the documentary Brother Number 1, which documents Rob Hamill's experiences of going to Cambodia, participating in this war crimes tribunal, and coming to terms with his brother's experiences and death. So that gives you an idea of the historical context, and against that background, the Khmer Rouge Tribunal was formed, and its correct name is the Extraordinary Chambers in the Courts of Cambodia, which is a bit of a mouthful. It has a variety of jurisdictional limits. Perhaps the most interesting is that to be tried in the court, you have to have either been a senior leader or one of the most responsible for the crimes committed. And this is a court that uses a mixture of international common law and civil law, which was particularly interesting for me, coming from New Zealand, i.e. a common law background. There are 3 chambers in the court. There's a pre-trial chamber, a trial chamber itself, and then also a Supreme Court chamber. And you may be aware that one of our previous Governor-Generals, Dame Sylvia Cartwright, is in fact sitting as a judge in the trial chamber of that court. So I didn't have a lot to do with her, given that she was a judge and I was a prosecutor, but working for the prosecutors, I should say. But she's very actively involved in the tribunal and has been for a number of years. The other thing that I wanted to mention briefly at this stage is that the tribunal has been explicitly set up with an element of a capacity building function to it. By that I mean it's not just a tribunal tasked with prosecuting the accused, but also trying to improve judicial and legal standards within Cambodia. There's a variety of mechanisms that have been implemented to achieve that, and I'll talk about that a little bit later in the interests of time. So far, the tribunal has successfully completed one case. That was against the former leader of the S21 torture centre, which is, if any of you have visited Phnom Penh, you know that you can go and visit that particular area. On appeal, his previous 35-year sentence was increased to life imprisonment, and he was found guilty of multiple crimes against humanity and grave breaches of the Geneva Convention, including extermination, enslavement, torture, and persecution. The current trial is of those 4 leaders that I mentioned a few moments ago, but in fact I say 4, but really it's 2, because the proceedings have been stayed against Ieng Turut because of her dementia and inability to continue participating in the trial, and Yang Sari passed away last month due to long-standing cardiac failure and problems. So in fact now there are only 2 of those senior leaders on trial. There are 2 other cases in the pipeline, and you may be aware that they're the subject of some controversy. There's been a lot of allegations of government interference in those cases, and whether they'll proceed or not is something that everybody is asking, and I can't provide any particular insight into that. But that gives you an idea of the kind of work that the court is currently involved in. So to turn now to the perhaps more personal side of all of this, like I said, I was working for the prosecution team, and you can see some of the members there. This is a team that's made up of both international and national staff members, and that goes back to the idea that I was speaking about before about the capacity building function of the court. It's what we would call a hybrid tribunal, which means that all of the departments, all of the chambers, all of the prosecution and defence teams are made up of both international and national staff members. So here you can see the National Prosecutor, Chia Liang, sitting next to International Prosecutor Andrew Cayley, and my boss, Bill Smith, is sitting on the left of him. So that was the prosecution team in terms of the permanent staff, and that's me working for Bill. He's a great guy, we got on like a house on fire. But also there's a large contingent of interns, which is what my role was. And these interns are also international and national as well, coming from all areas of the globe, all with legal experience, mostly lawyers in the prosecution team. But there are also interns working for areas like the Public Affairs Department who don't have that same legal background. So what was I doing while I was over there? It was a huge variety of work, and there was nothing at all of intern tourism, by which I mean going along and just sitting on the sidelines. It was a very, very practical, very full-on, very exhausting experience, but one that was incredibly rewarding for me. Within my first week, I was doing editing of an appeal to the Supreme Court chamber with regards to the Ieng Turut fitness to plead hearing. And throughout my time there, I did a lot of legal research across a wide variety of subjects. One example, which you can see me in the courtroom there, one example is a severance hearing, which was in the last 2 days of my time there, where the trial chamber had decided to limit the scope of the trial against the accused in the interests of time efficiency and resource constraints. And they're allowed to do that, but only if the limited trial is reasonably representative of the trial as a whole. So the question that I'll leave you to mull is, what does that mean? What does it mean for a trial reduced in scope to be reasonably representative of a broader set of charges, and that was the issue that I was doing a lot of research on towards the end. Other things that I was working on included documentary hearings. There are 400,000 pages of documentary evidence of the regime over those 4 years, and from time to time the trial chamber requires that the prosecutors present that documentary evidence in a coherent and persuasive form such that it comes to the particular attention of the judges and the public. So again, the question I'll leave you to mull is, how on earth do you pick the most important documents? But as I'm aware my time is drawing to a close, let me leave you with some of my impressions and observations. I had an overwhelmingly positive experience in Cambodia. I say this not lightly, that it was the best 6 months of my life, but it was definitely an opportunity to make observations about, first, what it takes to be an effective lawyer, and secondly, what it takes to run an international criminal tribunal well. And my first observation is that neither are easy by any stretch of the imagination. To turn to the first of the groups of observations I would make, being a lawyer requires a lot of long hours and a lot of really hard work. And one thing that I found very satisfying about working in Cambodia is that my bosses would be there working with me throughout the weekends and doing all that background work as well. So that was very satisfying. The second thing is that there was a constant need for flexibility. And so, to give you an example, you'll remember moments ago I mentioned Elizabeth Becker, the expert historian who I spent many hours preparing questions for. In fact, she's now no longer going to testify at the tribunal in the interests of efficiency and getting through the material that needs to be got through. So that's just one example of those many hours being written off, but which is just something that has to happen as a result of the age of the accused and the constraints that are operating. Finally, I've realised the need for impeccable communication. This is a tribunal that operates in 3 languages, English, French and Khmer, and effectively it's a negotiation between 4 different parties: the prosecutors, the judges, the defence teams, and also a group called civil parties, who I'll come to in a minute, but who are essentially victims that are legally represented and participating in court. That's something different to New Zealand, but adds another element of contention and of potential confusion to the tribunal's proceedings. But let me move now to my observations about the court itself, and this is where I want to finish. I think overwhelmingly the court is doing good and should be supported and should continue. But you may be aware that the court has been the subject of a lot of criticism, and that's not something I would disregard lightly. I've spent a lot of time thinking about why the court has been criticised a lot, and I think it's because the court is being asked to do 2 different things. It's first being asked to conduct trials which are highly complex, spanning multiple parties, multiple years, huge amounts of documentary evidence, and so on. But secondly, it's being asked to provide that social building function that I mentioned earlier. And that's not something which it shouldn't provide. It's just something that needs to be taken into account when considering or judging the success of the tribunal. So let me spend a few moments talking about the role of the court in creating social change. When the court was established, the then Prime Ministers explicitly said that the Cambodian legal system was not able to cope with this sort of trial and would need international assistance to that end. And that makes sense because approximately 80% of lawyers and legal experts who lived in Cambodia before the Khmer Rouge were murdered during the Pol Pot regime. And in fact, by the end of the Khmer Rouge era, it was estimated that there were only 10 law graduates remaining within Cambodia. So you can really see how you're starting from scratch when you're building up that legal system. So like I said, the court has a variety of mechanisms to enable it to achieve that capacity building function. The first is the involvement of civil parties. Like I talked about before, those are victims who are actively involved in the court process. And there were 3,988 applications to be a civil party in case number 2, which is the one I was working on. The second way that the court is attempting to achieve that development function is actually by being located in Phnom Penh. And that's very different to a number of other criminal tribunals that exist, which are perhaps in The Hague or in other places in Europe. And that has meant that ordinary local Cambodians can come and visit the court, and they have done in droves. There have been over 75,000 visitors to the court for case number 2 alone, which is the one I was working on, and 82% of those were Cambodian nationals. And the public gallery, which has several hundred seats in it, is always full during court days, with people coming, brought by free transportation to the court, to come and observe the hearings, hear the evidence, and so on. Complementing that is also an extensive outreach program involving things like television shows, speeches to garment factory workers, one springs to mind, those sorts of activities to publicise the court and make people aware of its functions. And the final point that I would say in terms of this capacity building function is that in fact the Khmer Rouge era wasn't taught in high schools until 2009, and it's the presence of the court and that dialogue that the court has opened which has actually made it now a part of the curriculum, which I think is very important. But all of those capacity building functions bring with them problems as well. I mean, having those civil parties involved naturally brings with it delay, which calls into question whether it's worth doing, and it's a value balancing exercise that has to be taken into account. There have also been a lot of allegations of corruption against the court, and there have been investigations into those allegations. But again, that needs to be seen in the context of the Cambodian legal system, which is that in the mere 6 months that I was there, Human Rights Watch released a report documenting 2 decades of impunity under the current Cambodian government. There was an ongoing trial of a radio broadcaster who had been jailed for making critical comments about the government. There was an ongoing trial of people who had been framed for the murder of a trade unionist, where the allegation is that government officials in fact were responsible for that death. There was an ongoing trial about unfair and unjust evictions from land by government officials in the interests of project development. So really this is a legal system that is hugely in a development stage, and while it's no excuse that some of those problems cross over into the International Criminal Tribunal, it perhaps does explain it to some degree and is something to consider when assessing the strengths and weakness of that tribunal itself. So anyway, that was fascinating for me to be thinking about and working in as I was there. But now the question is, as I draw to a close, where to from here? And as you can see, I'm still really buzzing about my time in Cambodia, and I miss it a lot, and I'd love to have stayed longer. But I am slowly starting to settle back into life in New Zealand, but I'm still getting my fix of tribunal proceedings by watching them through a live stream on the website, which I would recommend to all of you. I've just finished my professional legal studies course, which is, for those of you who aren't lawyers, the final thing you need to do before being admitted to the bar. And at the end of this month, I'll be starting work at Luke Cunningham & Clear, which is a firm in Wellington that holds the Crown Warrant, meaning they do criminal prosecutions in the Wellington region. So I'm really looking forward to developing my interests in prosecution and in criminal work, and that really is going to my longer term goal, which is to do international criminal prosecution in say 20 or 30 years' time, and on the way hopefully get a master's and become fluent in French. So once I've done all of that, I'll see you back here in a number of years and I'll let you